Good afternoon. Welcome to the Public Service Commission of South Carolina. We are here for a special business meeting. It is Tuesday, April 25th at 3:10 p.m. First, let me apologize for the delay in starting the meeting. We had a hearing that ran until just before 3 o'clock, and we needed to get reset with some of the technology that we use in the hearing room for streaming of the meeting. So I do apologize for the little bit late start time. Let's take a roll call of commissioners. With us virtually, we have Commissioner Irvin, and present in the hearing room, we have Commissioner Justin Williams, Vice Chair Powers, Commissioner Thomas, Commissioner Carolee Williams, Commissioner Caston, and Chair Belser. Before we begin today's meeting, would you join me for a moment of silent reflection? Thank you very much. Good afternoon, Mr. Powers.
Thank you, Madam Chair. Good afternoon, Vice Chair Powers and Commissioners. First, I would like to remind Commissioners that our next regularly scheduled business meeting will be held on Thursday, April 27th, 2023 at 2 p.m.
Thank you.
Today, we have one item on the agenda. Item number 1 is in docket number 2023-2E regarding the final disposition of Dominion Energy South Carolina's annual review of base rates for fuel costs.
Commissioners, we've heard the single agenda item identified by Mr. Powers. Is there a motion?
Madam Chair, I'd like to make a motion.
Commissioner Caston, I'm not sure your mic. Now we've got you on. Commissioner Caston is recognized.
Thank you, Madam Chair. I move that the Commission finds that no party to this case submitted evidence to support any disallowances of fuel cost. I move that the Commission adopt the stipulation between Dominion Energy South Carolina, the Office of Regulatory Staff, and the South Carolina Energy Users Committee, and find as follows. Number 1, the fuel purchasing practices and policies, power plant operations, fuel inventory management, and other matters associated with South Carolina Code annotated 58-27-865 of Dominion are reasonable and prudent for the review period. The base fuel cost component for Dominion is 4.352 cents per kilowatt hour for all rate classes. The total value of net energy metering distributed energy resource proposed by Dominion and with concurrence of ORS is 0.03093 cents for the current period and 0.04248 cent for 20-year levelized, as shown in the direct testimony of witness James W. Neely in Table 2 in his testimony. Number 4, the DER incremental cost component per account per month is $1 for residential, $7.91 for small, medium general service, and $100 for large general service. The total fuel cost factor is 4.439 cents per kilowatt hour for residential service, 4.467 cents per kilowatt hour for small general service, 4.452 cents per kilowatt hour for medium general service, 4.413 cents per kilowatt hour for large general service, and 4.352 cents per kilowatt hour for lighting service. Number 6, the DER avoided cost component is 0.041 cents per kilowatt hour for residential service, 0.034 cents per kilowatt hour for small general services, and 0.029 cents per kilowatt hour for medium general service, and 0.018 cents per kilowatt hour for large general service. Item 7, the variable environmental and avoided cost capacity cost component is 0.100 cents per kilowatt hour for residential service and 0.081 cents per kilowatt hour for small general service, 0.071 cents per kilowatt hour for medium general service, and 0.043 cents per kilowatt hour for large general service. Number 8, the company will be noticing its customers of the increase in fuel cost and explaining the nature of the fuel cost. This same notice shall provide information on resources to customers in need of assistance. Additionally, prior to its next fuel proceeding, Dominion shall provide a review of its forecasting methodology, focusing on the events of Winter Storm Elliott and outlining the steps to improve upon its forecasting analysis, especially with consideration of forecasting load during extreme weather events. Dominion must also provide a fuel plan for its gas-fired units, including any alternatives that the company has considered for alleviating the natural gas supply constraints associated with the company's firm transportation contracts and the cost of those alternatives. Finally, I move that going forward, Dominion shall use every reasonable effort to acquire all fuels at the most reasonable and prudent cost. I so move.
Thank you, Commissioner Caston. Commissioner Caston, I want to check a couple of numbers with you from my notes. For the net energy metering distributed energy resource, my notes reflect, and this is the part that was proposed by Dominion and concurred to by ORS, my notes reflect 0.04294 for the current period and 0.04434 for the 20-year levelized. Would you accept that as a friendly amendment? I think it was read, you had a different reading.
Yes, ma'am, I will accept that.
And also that the total, let me see, I had one other. I thought I had one other that I wasn't sure about, but I think that was the one. Those were the two. So it was just with regard to the NEMDER.
It was a lot of numbers, and
Yeah.
I apologize if I misread.
Okay. For clarity, but regardless, if we misstated the number, you were referring to the amounts that were included in the stipulation. Is that correct?
Yes, Madam Chair,
Okay.
it was.
So as long as we know that that's what we're referring to. Commissioners, we've heard the motion from Commissioner Caston with the friendly amendment that I offered and which he has accepted. Is there discussion?
Madam Chair.
Commissioner Justin Williams.
Thank you, Madam Chair, fellow commissioners. I concur in the result of Commissioner Caston's motion in that the stipulated agreement should be accepted because the law doesn't allow any other option. And if you would bear with me, I just want to go through a little bit of background. We heard a lot of talk about hedging and during the hearing, and we received some response from the company about hedging. And my recollection of the response the commission received when asking as to why the company didn't look into hedging is because of a 2012 order that essentially said that the utility, the SCE&G, should not enter or should not participate in a hedging program until ordered by the commission. I fully and completely reject that reasoning and rationale because the commission does not manage the utility. And the commission does not have any decision-making authority when it comes to the utility having the opportunity to explore hedging as an option. And considering 2012 was more than 10 years ago, there was no explanation offered as to why hedging wasn't explored. Not to say, fellow commissioners, that hedging is the answer, because it's not necessarily the answer. But when the law requires us to make sure the utility makes every reasonable effort to minimize costs, noting that they did not explore hedging, I don't see how we could find that. And Commissioner Caston, if I were to make that motion, even though I concur in the result, I would find that, or I would move that the commission find that the utility did not make every reasonable effort to minimize fuel costs during the review period. And let me go further and tell you why. I want to point your attention to a 2006 testimony by Ms. Rose Jackson, and the citation is 2006 5G. And the question starts here. Starts with, let me cite the page. Starts on page 21. I'm going to start at line 1. And the first question Ms. Jackson is asked, and this is in 2006, what effect does the volatile nature of the natural gas market have upon SCE&G? Her answer, as a direct result of price volatility, SCE&G can encounter extreme price changes in a relatively short period of time. This translates into unexpected price increases for its customers that may lead to, 1, social and economic costs associated with higher utility bills and alternative fuel use and declining use per customers. Just want to read 1 again. Social and economic costs associated with higher utility bills. So how can we find that the utility made every reasonable effort to minimize costs when Ms. Jackson testified herself in 2006 that a volatile natural gas market could translate into unexpected price increases for customers that may lead to social and economic costs associated with higher utility bills? Just want to put that on the shelf and think about it for a little bit, because the testimony goes on. The next question was, can the impact of gas price volatility be mitigated? Her answer, yes. From the outset, it is important to understand that SCE&G cannot eliminate or change gas price volatility. This is so because gas price volatility is influenced by factors beyond SCE&G's control. SCE&G can, however, attempt to mitigate the impact of gas price volatility by seeking to reduce its exposure to gas cost risk. While there is no best approach to gas cost risk management, the impact of gas price volatility may be mitigated through the implementation of a financial concept known as hedging. Next question. Please explain hedging. Answer. As used in the natural gas industry, hedging is defined as a practice of initiating a position in the financial market in order to offset the price risk deemed to be associated with the company's position in the physical market. Stated differently, hedging is a mechanism designed to mitigate the impact of price volatility. Next question, what is the purpose for implementing a hedging program? The purpose for implementing a hedging program is to help mitigate the impact of extreme price fluctuations, prices that SCE&G and ultimately its customers must pay for natural gas. As I stated above, the price of natural gas has undergone significant changes from the long-term, low-cost contracts of the industry's early years to the long-term take-or-pay price contracts of the 1970s and 80s to the current practice of acquiring gas supplies largely through short-term contracts at current market or spot prices. The reliance upon gas supplies based on spot market prices, sharply undermines the ability to anticipate, plan for, and control changes in gas prices. As a result, many gas utilities have undertaken activities designed to minimize the impact of price volatility. Today, the impact of price volatility is most often mitigated through the purchase or sale of financial contracts made available through financial markets such as the NYMEX. And this testimony goes on and on and on and on. And again, that citation is 2006 5G. And it gives a what I consider a pretty detailed analysis as to what a hedging program is and the benefits thereof. Now, this testimony was given in 2006. And we heard in this current case that in 2012, the company asked the commission to allow it to suspend its hedging program. The commission obliged. But that order in no way, shape, or form, from my reading, prevented the utility from bringing to the commission's attention the volatility. Well, first it started with instability and then trended towards volatility in the natural gas market that changed from 2012 to date. So again, I ask, and this is hypothetically, how can the commission find that the utility made every reasonable effort to minimize natural gas prices through the review period? A couple other observations I want to make. We received a stipulation a day before this hearing was scheduled to proceed. Once we heard that stipulation, we did not receive any evidence of any imprudency, unreasonableness, or anything to that degree. And when I asked, or Commissioner Irvin asked about hedging, the response was, we didn't do it because of the commission order. Fellow commissioners, I submit to you that once we accepted that stipulation and heard that stipulation testimony, and there was no mention of imprudency, unreasonableness, no suggestion or offering that any cost should be disallowed, that stipulation was as good as a done deal from the moment we closed that hearing based on the law. Because there's no evidence of record that allows us to disallow any cost, even in the face of not making every reasonable effort to minimize costs. The utility, based on the law, is still entitled to get that $384 million pass-through because no party offered any evidence to support disallowance. So again, another hypothetical question. What legal basis would the commission have to disallow any other fuel costs? None.
Madam Chair,
We wouldn't have any.
at the proper time, I don't want to interrupt my colleague, but I am going to ask if you will take some questions from him when he finishes his remarks. Thank you.
Go ahead, Commissioner Williams.
And so what I would say to the commission is that when we hear public comment about the commission operating through rubber stamping and not considering ratepayers' interest and so forth and so on, even though I know in my heart and I know in my fellow commissioners' heart that is not the case, it definitely has the appearance, considering they're based on the law, based on the record, there's no cost that we can disallow. Which raises another question. What value did we add to this process? Once the Office of Regulatory Staff reached a stipulation with the utility, along with the Energy Users Committee, and no one objected to it, why did it even need to come before us? What did we do other than have a hearing? We asked some questions, but what we were given was what the parties believed was fair and reasonable and supported the statute. So why should we even approve it? Again, it's hypothetical. I know the law requires us to do so, but just thinking creatively and thinking from the perspective of a ratepayer, what value did we really add to this process? I can't really see any. And the last thing I'm going to say, well, not the last thing, another thing I want to say, while I appreciate all the parties appearing before us, the Office of Regulatory Staff, the utility, Energy Users Committee, CCL, and all the other parties that I did not name, let me tell you something. I really missed the consumer advocate. I really, really missed the consumer advocate. And I don't know what they have going on by way of a docket or a budget or what reason they made not to appear in this case. But what I noticed, a couple of things I noticed when I first got into on the commission, Attorney Steve Ham, when he was the consumer advocate, has a lot of case law created here at the commission based on that advocacy. And I would submit to you that the consumer advocate's participation in cases before the commission is vitally important to getting a full view of how this case will impact South Carolina, specifically ratepayers in the service territory. The ORS does an outstanding job of representing the public interest, but the public interest is in my opinion, a utilitarian concept. The greatest good for the greatest number of people. But if you fall into that donut hole, you may not necessarily feel as if you're represented when the public interest is represented, even when it's well represented in the outstanding and professional manner that ORS attorneys represent the public interest. The consumer advocate, however, represents the consumer, the average everyday ratepayer. And we've had several cases here where the consumer advocate has presented information that was vastly different than the information presented by other parties, and in my opinion, was very influential. And I would go even further based on 5 years of experience as a criminal lawyer. Not having the consumer advocate present in hearings like this is similar to not having the victim advocate and the victim present in a criminal hearing before a circuit court judge. I'll tell you this, take my word for it. When the victim and the victim's advocate is not present at a sentencing or a plea in General Sessions Court, if you go back and run the numbers, I think there's an argument there that the outcome is a little bit different because there's evidence and there's facts that you don't necessarily hear, despite the fact that there's a circuit solicitor there putting the facts on the record. That's just an analogy that I would draw. So I don't know what we can do, but I think it's very important for ratepayers, residential ratepayers, to be represented by the consumer advocate. Last but definitely not least, I have to give some credit where credit is due, and that is to Commissioner Ervin, because it was very difficult to swim against the current and make the comments that I've shared with the commission today. But way back when we first got on the commission, Commissioner Ervin and I were charged with making a decision in the merger case. And one of the issues that came up that for whatever reason didn't get much traction while we were going through the case and briefing the case and discussing the case was the question of imprudence, whether or not the company acted with imprudence when they abandoned the 2 nuclear plants. And Commissioner Ervin, but for Commissioner Ervin attempting to persuade or argue for the commission to find imprudence, and I have to admit that one of my less proudest moments was not voting along with Commissioner Ervin at that time. But when he made the motion that we should find imprudence, that motion failed. And it failed because no one really addressed it or argued it for reasons I can't really understand, because it was obvious that imprudence was there. And I think sometimes it's important for the commission to just speak plainly obvious facts that exist and not leave the public wondering why and how we're making the decisions. Again, that's why I think it's important to find that the utility did not use every reasonable effort to minimize costs in the face of the fact that hedging was not even used in this case. Again, this is swimming against the current. It would be very easy just to approve this case and move on. But I just want to publicly repent and demonstrate contrition and vow to turn away from giving the appearance of rubber stamping cases and not asking enough questions and not using the law effectively to make sure we reach a fair and just outcome that considers all parties involved. It's hard to do that when the record is so limited, and in this case, limited to the degree that, quite frankly, if any other decision was made other than approving the stipulation, I would imagine that it would be overturned by a court of appeals, a higher court, and there would be carrying costs associated with that $384 million that would be put on the backs of ratepayers. We gave the company an opportunity to try to do something more, and quite frankly, they didn't have to because the law is on their side. And so we are where we are. And Madam Chair, I yield for any questions or comments.
Commissioner Ervin.
Thank you, Madam Chair. Commissioner Justin Williams, thank you for your remarks, and I could not agree with you more. The Consumer Advocate of South Carolina was a no-show. The most important docket, perhaps, in this decade. And why is that? The fact that consumers, ratepayers, all ratepayers, I'm not talking about just residential, I'm talking about commercial and industrial ratepayers, were not ever given a chance to submit testimony and evidence as to what impact a $384 million shortfall in fuel cost would have on their business, life, bills. And you know, I pointed out last week when we had a brief discussion about this thing, South Carolina has the fourth highest electric utility bills in the nation. And that calculation was made before Dominion got not one, not two, not three, not four, five, this will be number 5, rate case increases in the last 18 months. So I'm suspecting when that 17% increase, if you calculate those 5 rate cases, and assuming this is going to pass, and I'm sure it probably will, there were some commissioners that were ready to vote last Friday. They didn't really think we should ask parties to take another look. That's okay, you know. But here's the thing. Where was the consumer advocate? Why didn't the consumer advocate intervene in this docket to protect these ratepayers? Why was no expert testimony presented by the consumer advocate? And it's really a pretty simple formula. You know, you take the fuel cost for the period in question, and when there's a shortfall of $384 million that the ratepayers are now going to have to pay, why would we not have somebody here that's an expert in hedging that could show us down to the penny how much money could have been saved for ratepayers had we had a hedging program like I asked for more than 2 years ago? And as you recall, studies no evidence of record. I think a reasonable inference can be made that when a commissioner asks an investor-owned utility monopoly to implement a hedging program, which by their own admission, and you read the testimony, and thank you for your research in finding it, they knew all along that they could save the ratepayers money. You know what? The question is, why didn't they? Why didn't Dominion take steps to implement a hedging program? I'll tell you why. It's easy. They've got no skin in the game. You know why? The fuel statute in South Carolina provides that ratepayers will pay 100% of any shortfall during the annual review period. 100%. So why would they? I mean, it does no skin off their back, right? It's not going to cost them a thing. But, you know, it bothers me that, back to the consumer advocate being a no-show, I mentioned it last week. I said, is it too late for them to intervene? Probably is, you know. Could they move to reopen the hearing? Probably could have. I don't know. May or may not be too late. I don't know. There were a lot of things they could have done. Nothing was done. Nothing. And, you know, I hate to raise my voice, but I'm angry. I'm frustrated. And here we are at the end of a process. It's kind of a charade because ORS sees us as a rubber stamp. You know, I want to go through, I want to take the time. We got a letter from them last week. I'd like to kind of go through it, if you don't mind. Signed by Nicole Given. Now, Ms. Given's a fine attorney, and I want her to know I'm not disparaging her work. I suspect, and I don't know for a fact because I haven't talked with her, we're not allowed to talk with parties and attorneys, But I suspect that this letter was reviewed by her supervisors and most likely by the director of the agency. I believe that happened. Can't prove it, but I believe it happened. But let's look at the letter and just kind of analyze it. Just take the time to analyze it. It's dated April 24th, 2023, addressed to Jocelyn Boyd, Esquire, Chief Clerk and Administrator, Public Service Commission of South Carolina, regarding annual review of base rates for fuel costs of Dominion Energy South Carolina Incorporated for potential increase or decrease in fuel adjustment. Docket number 2023-2-E. Dear Ms. Boyd, on April 20th, 2023, the Commission issued Directive Order number 2023-250 in the above referenced docket. The directive requested that the parties of record review the stipulation filed with the Public Service Commission of South Carolina on March 29, 2023, and presented during the evidentiary hearing in this docket the following day to, quote, and these are your words, Mr. Justin Williams, they're quoting you here, determine if there is anything else that they can agree to that will reduce the sting of this proposed rate increase to ratepayers, end quote. The Commission further ordered the parties provide an answer to the Commission by 5 p.m. on Monday, April 24, 2023. So this is, there's timely response here. And then they go on to say, Section 58-4-50, subsection 9 of the South Carolina Code of Laws requires ORS to serve as the facilitator or otherwise act, whether directly or indirectly, to resolve disputes and issues involving matters falling within the Commission's jurisdiction. To that end, ORS entered into good faith negotiations with the parties of record in an attempt to resolve the contested issues in this case. ORS asserts that the stipulation is negotiated and agreed to by Dominion Energy South Carolina, the South Carolina Office of Regulatory Staff, and the South Carolina Energy Users Committee, collectively known as the, quote, stipulating parties, end quote, along with the benefits and concessions made by each of the stipulating parties therein, is reasonable in the public interest as defined by South Carolina Code Section annotated 58-4-10B, and in accordance with the law and regulatory policy. Moreover, the stipulation represents the final and complete agreement of the stipulating parties. Stipulating parties further agreed to cooperate in good faith in recommending that the Commission approve the stipulation as a fair, reasonable, and full resolution of the issues set forth in the company's application and pre-filed testimony. Similarly, the stipulating parties agreed to support the issues as agreed to in the stipulation and not undertake any action that would undermine their support. And what they're saying there is, that ties the hands of the energy users, because in order to get their little concession on their rate, they have to in turn agree not to post the overall deal. And, Attorney Scott Ellis, an excellent lawyer, I have the utmost respect for him. And, of course, he was doing his job. He got a good deal for his clients, and good for him. The other thing is, and this is what's kind of interesting, there's no mention of what we asked them, what you asked them to do, and that is to look for other ways to see if the impact on ratepayers, the sting on ratepayers, can be mitigated or reduced. They didn't even talk about it. They didn't even consider it. Justin Williams, they didn't even listen to you. They just want you to rubber stamp it. Because, that's what we do. We're rubber stamp people. The law is drafted by monopolies, investor-owned utilities, and it's in their favor. And to make matters worse, we've got a consumer advocate that fails to participate when millions and millions and millions of dollars are on the line. And now these poor ratepayers are going to have to pay the price. Once again, it always falls on the back of the poor ratepayers. You know, something's wrong here. And if you kind of read between the lines, you know, I think ORS does a great job. I think they follow the law. They have excellent attorneys. They have an excellent staff. But what is the PSC's role? What is our role? If we don't get the proper testimony and evidence to make a record, how do we make a fair and impartial determination when we don't have the testimony and evidence? What can we do? Well, you know, it's interesting. I asked one of you last week, and I'm not going to identify you by name because I don't want to call you out and embarrass you, but I asked one of my colleagues, I said, how many other states in the United States designate their utility commissioners as judges? You know, there are 50 states. There may be one other. I think it may be Virginia. But I think this is all part of a plan, really. If you think about it, judges can't write guest editorials. Judges can't comment on pending dockets. Judges aren't allowed to attend a Rotary Club. Judges aren't allowed to talk to anybody. You can't talk to anybody at church about pending dockets. You can't receive an email about pending dockets. You can't respond to an email about pending dockets. You can't have visitors at your office. You don't even take incoming calls, you know. It's like the joke that former Chief Justice from Spartanburg, Bruce Littlejohn, used to say. Well, after he retired, he said, you know, I feel like a call girl without a telephone. Nobody ever calls me anymore. You know, I used to be Chief Justice, and he laughed about it. But, hey, nobody calls us. They can't. So they gave us the title of judges for a reason. And I think you know what that reason is. Justin Williams, I don't know if you're willing to share it with the group, but I'll tell you what it is. If something goes wrong, like, let's just say, for example, an SCE&G nuclear debacle occurs, and their executives get caught lying under oath before the commission, the whole process blows up. And millions and millions and billions of dollars have to be shifted in the backs of the ratepayers. Who gets blamed for that? Who got blamed for that? So the damn public service commissioners, what were they doing? They were asleep at the wheel. You know, what were they doing approving all those rate increases month after month after month? Well, you know, they're judges, so they can't come to their defense. Nobody can say, we didn't know, or we didn't know that they were going to come in and lie to us either. But thanks to a whistleblower who had a conscience at SCE&G, FBI got involved. And funny things happen when people start being held accountable. I raise that. The irony of it is, here's the irony. Think about this. If it hadn't been for that honest whistleblower, mid-level person at SCE&G that knew this was wrong, that knew this would cause ratepayers to pay millions and millions and millions of dollars they should never have to pay. She had the conscience and the good sense and the honorable soul that she was to come forward and blow the whistle. But you know what? If she had not done that, you know what the irony would be? Dominion Energy would not even be in South Carolina right now. It would still be SCE&G. Think about that for a minute. And yet, tonight, the former CEO of SCE&G will be tucked in the federal penitentiary somewhere in North Carolina. And I hope, I hope that sends a message to others. Might try to deceive. There's a lot of temptation, and when you set salaries with bonuses that provide, you get several million more dollars. I think he was scheduled to get $10 million in incentives to complete that debacle in Fairfield County. And that's why they drug it out for so long. They wanted those bonuses. Something's wrong. Something is wrong when we find ourselves in a situation like this. So, Commissioner Justin Williams, I want to thank you for doing the research, for going back and finding the sworn testimony. Of course, the company knows they can save ratepayers money by hedging. And yes, they did get asked by me and others to implement a hedging program, but they refused to do so. I think that in and of itself is unreasonable and imprudent. You know why I think that? Because if we approve this order today, and I suspect that y'all got the votes to do it, I won't be voting for it, but I guess some people will. $384 million. $384 million will have to be paid by South Carolina ratepayers. And ORS says, well, we'll have to pay the carrying charges. We got that negotiated away. Well, thank you so much. It would have been a shame to have to pay interest on top of that number. We appreciate that. But what about, back to the facts in this case? You said, Commissioner Williams, there's nothing in the record that supports imprudence. I want you to think back for a minute about the last two lay witnesses that we heard from Charleston, I believe it was, on March the 30th, 2023. At the end of our hearing, a very short hearing, because, the consumer advocate didn't even bother to step by, so it was a short hearing. But those ratepayers, I don't even remember their names, but it's in the transcript, you can read it. I asked the gentleman that called in virtually from Charleston, I said, do you think it was imprudent or unreasonable for Dominion not to implement a hedging program back 2 or 3 years ago when we asked him to? His testimony under oath was, yes, sir, I do. It was imprudent and it was unreasonable. And for that reason, they should not get this approved fuel rate increase. And then the lady that followed him said something to the same. She said something similar. So there is some evidence in the record. After all, what about that? Is that enough to hang your hat on? That's what I'm going to hang mine on. I've already told them, several years ago, that's what they should have done. And, history repeats itself. Nobody learns from history much, It's a sad thing because it does repeat itself. And natural gas prices increased by 110% in one calendar year. Who would have known? Who could have foreseen that might happen? I'll tell you who. All the other utilities in the nation that hedged, they saw it coming. They made appropriate financial plans for their ratepayers. We weren't so lucky in South Carolina. So lucky. And it's kind of sad that our role as commissioners now, we're rubber stamps. And, maybe they ought to just have a drive-through window. Why have a hearing? It's kind of like go through the bank line, stick to order. They've already sent us an order, by the way. They sent a proposed order. Doesn't mention a thing about hedging, by the way, even though we've repeatedly asked them to implement a hedging program. Let's just have a drive-by window. You know, an employee from ORS can throw the proposed order that's been consented to by whoever was a party to the action, and let our clerk have a rubber stamp, big one, that says approved. Thank you. Have a good day. Why don't we just do it that way? Why do we go through this charade of calling it a, quote, hearing when the consumer advocate of South Carolina is a no-show? What's wrong with that picture? There's something bad wrong. And, you know, I don't know how you justify, Commissioner Caston, asking this commission to saddle the ratepayers of South Carolina that live in the Dominion territory to pay an additional $384 million just for the 1 year. Now, that's just 1 year. And they still don't have a hedging program. $384 million. Wow, that's a lot of money. And, you know, there's nothing anybody can do about it now. Record's closed. Got the rubber stamp ready to go. Stamp that order. And let's see. Bills go out May the 7th. And, of course, we don't want to company to wait to get their money, do we? I mean, we're in a hurry. We got to push this through. You know, can't wait. It's got to be done now. My question is, why does it have to be done today? Have we really sat down, considered other options? Did ORS and its confidential settlement negotiations with the parties that did show up, which there are only two other parties, Scotty Elliott got a little help for his clients, and he's a damn good lawyer. And you know what else? Dominion's got a heck of a team. You know, if we were going to grade legal talent, I believe Dominion's would be number one. They would be the best because they run circles around everybody else. I mean, they've got plans, and I commend them. I really do. I think that if we were grading them, if we had to rank them like they do in the SEC or the ACC, they would be number one every year. It's a Dominion dynasty, and I think that's great. If I were, and I'm not, but if I were a investor-owned utility in this country and looking for a chief counsel, I would get Mr. Gissendaner on the phone and tell him, we want to make you an offer you can't refuse. We've seen what you've done in South Carolina. You've won 5 rate cases in 18 months. You know, it'd be like recruiting. Why don't you go to the portal? You could triple, maybe quadruple your salary. And you're a young man, you've got plenty of time left. I mean, why? I don't know. Maybe you've got family ties here. I don't know what your personal situation is, but you're a talent, man. And congratulations. You know, who would have thought that they could get 5 rate increases in 18 months?
Commissioner Irvin, can we get back to the case, please?
Sure. And so let me talk about the case a little bit more. Got a few more thoughts for you. Just wondering, Commissioner Justin Williams, have you thought about the possibility of moving to reopen the hearing record? And if so, tell us about that. Is that an option that we should consider?
I've been told that's not an option.
Not an option.
But I would, if I'm wrong, I would love to be corrected. But I've been told that it's not an option to reopen hearing.
Not an option. Okay. How about my contention that the lay witnesses alone, coupled with my request, which is established in the record, for Dominion to start a hedging program before this happened, isn't that evidence of imprudence? That in and of itself, they knew. We put them on notice, and they failed to act.
Commissioner.
I don't know if it's evidence of imprudence, but
Yes.
what I will say is I don't think they made every reasonable effort to minimize cost. The issue I have with that, Commissioner Irvin, I thought about rejecting the stipulation, but the trouble is that the company did buy natural gas, and their customers used it to heat their homes, cool their homes, cook their food, so forth and so on. We don't have an analysis. I guess the frustrating part is there's not an analysis to support any level of disallowance. It's a pretty, I mean, I don't want Dominion's lawyers to take this the wrong way, because I mean it sincerely. For the part, or really the stipulating parties. For the stipulating parties, it's an airtight deal. I don't see any way to disallow any cost. There's no evidence to support disallowance. Not a percentage, not a dollar figure. It's a take it or leave it deal. And if we reject the stipulation, my understanding is that the original request is the only thing that's on the table, and even there's no evidence to support disallowance other than disallowance in full, and I don't think that would withstand review, because I'll just leave it at I don't think that would withstand review at a higher level. And so let's walk this all the way out. We reject the stipulation. We deny the rate increase. Another court is going to review that. I think it may be the Supreme Court, since it's a rate case. They're going to review it, and there's case law that says the commissioners they sit as subject matter experts and so forth and so on. But there's also necessity for there to be a legal basis and a basis within the record for us to reach our decision, and I don't see where we have a record to support full rejection. Now, I understand everything you've said for the last, 30 minutes or so, but do you see a basis in the record to reject the stipulation in full, reject the rate request in full, and do you see the law supporting that?
Well, you make a good point, and that is that we don't have a full and complete record. And this is another thing that I find so disappointing and disheartening. We are in a situation where other people fail to do their jobs, and now we've run out of options. And that's not a good place to be in, is it? I'm just wondering, what can we do going forward to prevent this from occurring again? I'd like to hear you discuss that. Talk to me about that.
I think that we can hire additional staff to help us review cases, because you're going to have an incredible level of foresight to, just think about this. In 2006, in September of 2006, I had recently graduated from the University of South Carolina, and I was working as a pharmaceutical sales representative in Atlanta. And that's where I had to go back to. I had to go back to that year in order to get information about the company's position on hedging, because when asked in the case, the response was the commission told us we couldn't do it. And that response, to me, sent the message that, well, if the commission would have acted, then we would have looked into it. But they had already looked into it in 2006 and already testified to the benefits of a program. So we're going to have to, if we want to do something different, we're going to have to make an incredible effort to look deeply, 20, 30 years back, into orders and memorandums of understanding. We may have to see if the statute that allows us to hire an expert will allow us to hire an expert to give an analysis on, in this case, if in hindsight, if I could do it again, I would want to see if we could hire an expert to determine whether or not hedging during the review period would have provided any ratepayer benefits. There's nothing like that that's on the record.
Yeah, isn't it just common sense though that it would have provided ratepayer benefits had they had a program?
Not
it's not
necessarily.
that complicated.
I respectfully can't make that leap, Commissioner.
Well,
And
you know,
it just depends. That market, I'm no hedging expert by any stretch of the imagination, but that market changes hourly, I think, and maybe even more than hourly.
it does.
And if
right.
if you're on the wrong side of it, you may not. Now, there may be some savings, but there's going to be cost associated with implementing a hedging program. And please remember that in the mid-period adjustment order, we ordered that the company come back in the 2024 fuel case and present some studies on hedging. And I don't even think we need to go back to Ms. Jackson's 2006 testimony to talk about hedging, because in her direct testimony in this case, she has a section on hedging of natural gas for electric generation. And let's not confuse the dockets here. The order 2012-39 that suspended hedging for SCE&G was in a purchased gas adjustment case. It was a PGA case. That last fall, the PGA case, the commission order, and I think it might have been in a agreement with ORS, that the company would come back in the 2023 PGA and provide results, do a study, see if hedging is something that needed to be implemented. Again, I've got some issues with the 2012 order anyway. I don't think it's up to this commission to order the utility not to do something until the commission rules later. I think that's crossing the line into trying to manage the utility, but that's a whole different matter. So they have agreed, and it is in 2 commission orders, that the company will study the hedging issue, bring it back in the 2023 PGA case, and in last year's fuel docket, in the mid-year review order, my recollection is the company said they didn't have time to do a study on hedging for the 2023 docket, since they would be filing testimony like within a month or two of that order. They agreed to, and it was put in the order that they would come in the 2024 hedging. Now, what Ms. Jackson said in this case and in previous fuel cases, the company has not engaged in hedging for electric generation. I think the testimony in the record shows that the company relies on economic dispatch, so that they are pulling the least cost, they're starting up the next least cost generating unit to save fuel cost. And that's what she's testified that that the company has never, I believe, never, and I think Mr. Neely said this too, engaged in hedging on the electric generation side. The hedging that the company used to engage in was on the LDC side. So I don't even think we need to go back to the 2026 testimony. I will note, I don't think we're a rubber stamp. Every witness that pre-filed testimony in the fuel docket was put up to testify and was subject to cross-examination by parties, which they chose not to, but were available for questions by the commission. We have to evaluate the record before this commission. That's what the law requires. And that's what we have to do. And I will note that the stipulation did result in some decrease in what was originally filed for by the utility. Now, also, while I would like to see the consumer advocate in these cases, I'm not going to criticize them. I don't know their workload. I'm not as intimately familiar with their statutory provisions that allow them when they can intervene in commission cases, but I leave that to them. And I think that they come in and they add value to the cases that they participate in. I think that they've done an excellent job thus far in the cases that they participate in, but I am not going to engage in criticizing them when they choose not to participate. Anyway, but I do take exception to saying that we're a rubber stamp. We have parameters by law that we have to abide by. We have to review the record and make the best decision that we can in compliance with the law that applies to the case as well as the laws that apply to us as commissioners. And I really resent this rubber stamp accusation. So, Commissioner Caston, you're recognized.
Thank you, Madam Chair. You've actually touched on a couple of things that I was going to address. I was told and learned a long time ago, anytime you try to defend yourself, it looks like you're defending yourself. So with that being said, clearly there's passion and emotion relative to this issue. I get it. I understand it. And Madam Chair, I didn't agree to serve in this role because I thought it would be easy, or because I thought every decision I make everybody would like. It's not why I'm here. I didn't ask a soul on this commission how they're going to vote. Not a one. Matter of fact, I didn't finish the motion before she was calling us to order. I didn't rubber stamp a thing since I've been here, ever. Matter of fact, y'all been mad at me more than once. Every one of you, every single one of you, and you still love me, and I appreciate that. We sent this back last Thursday. We agreed to it. They responded. We didn't say send it back and if we don't like your response, we're going to be mad about it. We said we're going to send it back and see what you can do. Well, they sent it back and said, well, we appreciate it, but we're where we are. And by statute, we're required to make a decision. Simple as that. And in my opinion, and I'm not speaking for the commission, this is my opinion, I don't think it's ever wise for us to tell the utility how to run their business. I just don't think that's our job. Whether they use hedging, don't use hedging, whether they use a crystal ball, I don't know. But that's their job. It is my job, based on the testimony and the law, to determine did they do a reasonable and prudent job of doing their job. And if the evidence in the record indicates they did not, then we make that decision. If it indicates they did, then we make that decision. Because I cannot create the record. The record is what the record is. So, again, I understand the passion. I'm not absent passion. I don't think anyone here is. But my job isn't to be passionate or emotional. It is to make a decision based on the record and the law. This motion, I believe, does that. In particular, that last sentence, at least is my intention, to not tell the utility how to do this, but tell them it's their job to do this, and we'll judge it and weigh it when it's time to judge it and weigh it. And I guess, like Forrest Gump, Madam Chair, that's all I got to say about that.
Thank you.
Thank
Commissioner Thomas?
Thank you. And thanks to all of my fellow commissioners and the comments that have been made. I agree with some comments and disagree with some comments, but I'd like to talk just a little bit about hedging. First of all, I'd like to just say that hedging is not a guarantee, and hedging does have costs. And there's been some discussion about the 2012 order, and I certainly don't know the details behind that, but it is my recollection that at that time there were significant costs hanging out there related to hedging, and maybe the number was 56 million. I just don't know, but it was a big number to me. And so I think the consideration of hedging or not hedging is an important decision. It's not something that should be rubber stamped, and it is a decision that is to be made by the company. There are a lot of things that I think should come into account and into play in connection with making that decision, and just a lot that I need to know. I'm certainly not an expert on hedging, far from it, and I need to know a lot more about it before I'm asked to make a decision on that. And just a couple of thoughts along those lines. I'd like to know such things as the Dominion Company overall. Are they engaged in natural gas hedging in any of its other entities, either gas or electric, and in any other states? And if so, how's that working out for them over both the short term and the long term? And additionally, has Dominion or any of its entities previously, let's just say over the last 10 years, engaged in natural gas hedging, whether it was in the electric or gas utility, and what were those results? And in relationship to the 2012 program that was discontinued, just out of curiosity, is it possible to run a cost-benefit analysis as if that had been continued through this fuel proceeding, both over the long term and perhaps over the short term, last couple of years? What would the results have been? And I do not know that that can be done. I don't know that you can go back and, let's just call it second guess, making that calculation. Another question that I would have is, does natural gas hedging, the way it operates now, would it cover both the fuel and the transportation cost, or one or the other, or both? I don't know. And a lot has changed since 2012. That's why I have these sorts of questions. And another thought that's been thrown out there a few times is there any potential for the benefits or the costs of hedging to be shared between customers and shareholders under South Carolina law? I don't know the answer to that for sure, but perhaps if that is possible, then that may give the company some incentive to engage in hedging activities if all factors come together to make that look appropriate. Long and short of it is, there's a lot to know about hedging, lots of ways that can play out, both in the short and long term, and it's not my place to tell the company to do that. And I would just, at this time, leave it at that. Thank you.
Thank you, Commissioner Thomas. Vice Chair Powers?
Thank you, Madam Chair. Like Commissioner Thomas, I agree with some things on both sides. I do believe that asking the parties to reconsider the agreement was a very fair request. And I hope, even though we got what was a quick answer of no, I do hope that that was done as we requested. It sounds like in this particular situation, whether the public can understand it or not, we're pretty much held hostage by the statutory requirements of fuel costs. But we're not held hostage in every case. And I hope the public could understand that by approving this, doesn't mean that one person sitting up here agrees to an increase. Ratepayers in South Carolina and everywhere now, as well as the general public, are having to tighten their belts. At the same time, we're asking them to pay more. And I just wonder, it won't be today, but when do the shareholders tighten their belts? And I think everybody's got to work harder to make things work. I think everybody's going to have to tighten their belts, just as we all do privately in our own lives now, with the way things are. But I'm looking forward, and we can look back all we want, but I'm looking forward to see what does it take to come in here and have a case where we're not beating up the ratepayers. And I hope that's soon. Thank you.
Thank you, Vice Chair. Commissioner Carolee Williams.
Thank you, Chair Belzer. Like my other colleagues, I appreciate and agree with many of the comments that have been made today. The vote I took last week to allow additional information to be filed was not intended to suggest that the parties had not done their best work in presenting the stipulation. Instead, I supported the short window of opportunity, understanding that all participants in this docket, and especially Dominion Energy South Carolina, may have become aware of another opportunity that was not clear at the time of the presentation and the conclusion of the hearing. I appreciate their consideration given the impact to customers' bills, residential and business. I am going to support the fuel increase. It, along with the mid-year increase, represents approximately a 10% increase during an unprecedented year of inflation. And while the increase will hurt our bank accounts, this increase is in line with what the U.S. overall has experienced. The request that is before us is about 30% lower than what the company requested. And the reality is that with the stipulation, it's not possible for the Commission to know all the details of the negotiations between the parties that resulted in that stipulation. What weighs heavily on me and helps me to make this personal decision is that the Office of Regulatory Staff and the South Carolina Energy User Committee entered into the stipulation, and no other parties argued against that stipulation. I note that while the increase is an impactful 3.9% for residential customers, there's a higher burden of increase coming to the business customers between about 4.6% and 7.11%. But in plain English, I think this is as good as it's going to get given the Commission's statutory authority. Do I wish that Dominion Energy had reliable, renewable, low fuel cost resources? Yes. But the time for that evaluation is in the upcoming integrated resource plan to understand that question fully. Do I wish there was an opportunity, as others have said, for there to be an incentive for Dominion to minimize fuel cost? There are opportunities like cost sharing between customers and shareholders. Yes, but that's a statutory function for the legislature to consider. The bottom line is the Commission is going to make this decision based on the facts entered into the evidence and understanding that Dominion Energy may only recover their actual expenses with no markup as defined by state statute. Thank you, Chair Belzer.
Madam Chair, I request we call the question.
Thank you, Commissioner Williams. Commissioner Caston calls the question. We'll proceed to a roll call vote on the motion as amended. Commissioner Caston.
Aye.
Commissioner Ervin.
No.
Commissioner Thomas,
Aye.
Commissioner Justin Williams,
Aye.
Vice Chair Powers,
Aye.
Commissioner Carol Lee Williams.
Aye.
I vote aye. The motion carries. Mr. Powers, is there any other business to come before the commission?
That is all.
Thank you. Thank you all very much. This meeting is adjourned. We will, we'll have our regularly scheduled business on Thursday at 2 p.m. Thank you. We are adjourned.